Welcome to Inspiring Business with your host, Mark Bullock, who is the co-founder of videosocials.net and of videointerviewpodcast.com. In every episode, Mark interviews business and organizational thought leaders who share their stories of how they inspire others by making a difference. You can find this show on videosocials.net and YouTube, LinkedIn, Facebook, and almost any podcast platform of your choosing.
Welcome. And today I'm really happy to have David Cohen as my guest. And David is a highly experienced intellectual property or IP attorney. He's the president of David L. Cohen PC and Kidon IP Corporation. David advises on IP strategy, litigation, licensing management, just to name a few. And I found it interesting that David was listed for multiple years on the IAM 300 as one of the world's leading IP strategists. We've worked with David for a number of years. It's wonderful to have you, David. It's been a long time. It's great to see you again.
It's been a long time. It's great to be here. It's great to see you again.
Awesome. So I always like to start, as you may know, David, with what's your story, and really that comes down to what's inspired you to be what you are. And as I was kind of going through some of your bio information, I learned things about you that I didn't know. And your studies, as far as for all your degrees, varied all over the place, from history, philosophy, political theory, not to mention law. You've been engaged with some of the top institutions in the world: Johns Hopkins University, Cambridge University, University College of London. And how did all of that and who you are have you be, what I want to be when I grow up is one of the world's leading IP strategists?
Well, it's not as diffuse or diverse as it may seem. Let me explain. I've always been a big picture guy, and I found a word early in my late in my youth, early in my adulthood, called synoptic. I've always been a synoptic thinker, big picture, how it all fits together. That's just how I am. That's how I'm wired. I can do the details, but it's not my fun thing. I like to see how it's all connected. And when I was in my youth, I was fascinated by the interplay between science, politics, religion, and technology. And I was fascinated by figures who like to have a grand theory of it all, whether it goes back to the Middle Ages or antiquity, where that was very common, like Isaac Newton. You read about Isaac Newton and his stuff that we don't read today, his politics, his religion, his theology. It's all together. He had a theory, and I wrote a paper on how he believed that the structure of the temple in Jerusalem was how the atoms were structured. And, that's why he studied these texts. So for me, I was always fascinated, and I wanted to do advanced graduate work in this. And the last time sort of in history where you could probably get away with having a grand unified theory of everything and not be a complete crackpot and, wear tinfoil hats, was the late 18th, early 19th century. So I was a late 18th century specialist, and I did graduate work in that period. And sort of my final, and I was good, but not good enough. I wanted to do a PhD, but I couldn't get funding. That's my excuse, and that's what I'm going to stick with. But I guess the last program I was at, where I sort of got my footing, at UCL, University College London, what I ended up doing as my master's thesis was sort of a comparative history of patent law in Germany and England through the prism of a particular case. And that ultimately got looking at it from a cultural and sociological and legal history perspective, and why all of that bears on how, even though the law was theoretically the same in Germany and England at the time, and because of the European Patent Convention, the law wasn't going to be interpreted the same because of these cultural political factors, history. And that's how I looked at this prism of the case. And so two things happened. First, my wife said to me, my then fiance said, "You're insane. Why don't you become a lawyer? You'll do the same thing and you'll make money." And so I did. And then, it was very helpful too, because that sort of got me grounded in what I want to do in the law. And it was actually the law review article came out of that thesis, and it was published when I was when I graduated from Northwestern, at the Northwestern Law Review. So that's sort of how I fell into law, and sort of it colors how I view things today. I guess my notoriety, or my claim to fame, and one of the reasons why I was in the IAM for many years was I'm one of the I don't call pioneers, but one of the early and most prolific and big mouthed about it practitioners of global patent litigation, global patent strategy, how to sort of structure licensing on a global campaign. And that, I think, falls from both taking a big picture, looking at different cultures, how they utilize the patent system. One of the more fun discussions I had in my career was with some Brazilian lawyers who are wonderful lawyers, and we were looking at how to do a litigation or file litigation in a preferred district in Brazil, against a foreign company, or a company that was owned by a foreign company, a local company that was owned by a foreign company, and wanted to sue both, and sort of how to attach jurisdiction there. And they were explaining to me the rules in Brazil, in the Brazilian legal system, in terms that I didn't quite see how we could do it. But then I came up with this concept of pendant jurisdiction, as common lawyers would know, and I sort of was translating it, using it, trying to find ways to translate the concept, and it totally worked, and that's what we ended up doing. And so it was interesting just to use this sort of comparative law thing and thinking big picture stuff, and it got me hooked about how to connect different things that seem different in a larger whole, in a larger narrative, for a specific goal in mind. So that's sort of how I got into it, and I like IP. What's nice also about IP is that what's nice and dangerous about IP, let me put it that way, is that the law changes at a slower pace, although recently there's been some crazy changes. Crazy change of pace also, and I think the laws changes are crazy, but the pace has been crazy. But it's about something that's endlessly fascinating. You could certain areas of the law, all due respect to securities law or contract law disputes and stuff, it's about stuff that's been around for many, many years. And it's not, how many times you have innovation in, building, contracting structures, not the structure you're contracting, but how the contracting entity is
Yep.
Right? It's the same sort of players. But, in IP, you're dealing with technology that's cutting edge and changing constantly. And the uses are constantly changing, and how the business of IP, or the business relating to the technology, which is ultimately why you're getting the IP in the first place, changes constantly, and it involves politics, it involves international trade, it involves antitrust, it involves all different things. Well, antitrust, politics, what's the difference? But that's just a dig at antitrust. And it involves a lot of different things. It involves international finance. It involves personalities from all around the world, cross-cultural confusion, and it's really, it's a heady brew, and that's why it's dangerous. And sometimes you forget, well, I just need to earn a living, or these people just want to, protect their technology. They're not interested in all this stuff, and that's true, and that's sort of the trap that IP people can find themselves. But it is all related, and it's just fascinating, endlessly fascinating to me.
It's fascinating to hear that you're fascinated by it. It's in many ways, because we don't necessarily think of it, because my first question is it's kind of where the rubber meets the road, right? And for most business people, and that is, how do you make money from intellectual property?
Well, that's the challenge, right? So, and I think, not to play lawyer, it's a little definitional, right? So, what do you mean by that? And what is, let's take a further step back and separate out intellectual assets as the broader class, of which intellectual property are a subset. Intellectual assets are the stuff in your brain, the stuff in your technology, your relationships with people, anything that you have. And as opposed to a thing like a computer or a chair. And most businesses nowadays, I think I have it on my website, like 60% of the GDP in the US is attributable to intellectual assets, right? And a lot of those assets are protectable as some sort of property or contractual right. And some, and many of those are just trade secrets, which are intellectual property right, which is, recently the laws have been updated and unified, and so that's IP as well. And then there's a subset of IP which I call registered IP: patents, patents, copyrights, and trademarks. You have to register it and go through a process. And so, how do you make money from your IP? Well, in an ideal world, you make money by having the freedom, having investors, having people want to partake in your business for which you got IP because you have the IP. So a lot of companies get patents and trademarks and protect their trade secrets, not because they want to keep stuff secret, and not because they want to have a fancy piece of paper from the government that entitles them to sue people, but because it's a marker of seriousness. It's a sign that you're protecting that which drives the value of your business, so that you can have investors invest with confidence, so that you can have clients and customers interact with you in confidence, knowing that their secrets will be protected, or that you have the right to license to them that which you're licensing, or to develop them or sell them. So that's sort of like the foundational aspect of it. But there's a lot of other layers to it, which is that, why would you get something? So my specialty, I do sort of trade secrets to patents, but mostly patents. Why would you get a patent? Because a patent is very expensive to get. I'll be frank. It's not cheap. And given especially the crazy state of the law that I sort of alluded to, it's not clear that any patent that you get will be worth the paper it's written on, because there are so many ways that your patent can be killed or found to be not infringed that, you sort of wonder, why am I spending all this money? But why are you spending all the money? A couple of reasons. First, it often, especially in the early stage, and it all depends on the stage of the business you're in. Are you a startup? Are you in the office? Are you like in your garage? Are you a startup? Are you a small company? Are you a growing company? Are you a mature company? Are you a decaying company? Right? Are you a bankrupt company? And all their answers to those questions all sort of depending on where you are. But at each stage, the general principle is having IP can inspire confidence that you've at least had to convince some third party that you actually have some technology worth something. So that's sort of why a lot of investors want that. But also, it can act as a marketing tool or deterrent to your competitors, or marketing tool to your customers. There's a reason why Apple, for many, many years, used to publish and cause to be published in a lot of magazines all these patents. And they were published regularly in the Federal Register and whatnot, but they would use them as discrete marketing tools. And so many companies do that because it says, oh, we're doing cool stuff. But that, it can get an expensive type of marketing. But if you're a big company, you don't care. Small company. But having some patents that are pretty, that at least facially look like they're defensible in court, can act as a deterrent. Another reason why companies get patents is that you've ever tried to, and I'm sure you do this in your regular business, Mark, and many of the listeners probably do too, try to articulate a complex set of relationships, know-how, tacit knowledge, and all this other stuff that is providing that, in the case of a patent, would be providing the value drivers of a complicated organism that is a business. It's not easy. It's not easy. And truth be told, many patents do not articulate that fully, but they articulate a slice of it. They are registered by the government. They can be fully licensed. They can be fully divested and sold, and like a security almost, it could be. And so in many instances, a patent or a set of patents or a portfolio, a large set of patents, act sort of as a proxy for not that they're excluded from, but they act as a proxy for that set of intellectual assets that drive the value of the business that's being sold, that's being leased, that's being licensed, that's being mortgaged, that's being collateralized, that's being divested, whatever it is. And, I've done any number of M&A deals back in the day when I was at the big firm at Skadden, and you see these deals, and the diligence is, you read the portfolio patents and what's being licensed and sold, and there's a lot of other stuff that's really providing the value. It's not this piece of paper from the patent office that's providing the value, but the patents sort of stand in their place because they can be sold, they can be collateralized and whatnot. It's very hard to collateralize the stuff in your engineers' heads.
So just as you're saying this, and this is not something that we had discussed before, but it would seem to me, as a growing company, I would categorize this in that realm, the process of whether it be patent, copyright, or anything else, also requires you to, as the owner or principal, or one of the owners or principals of what it is that you've created, what it is that you've invented, in really forcing yourself to truly define it and to truly define its value, right? To a level that you may not do otherwise, right? Because, and in doing so, it would seem to me that it would help to crystallize.
100%. And I can't tell you how many companies have had these, have engaged in what I call an IP audit, where they do that kind of exercise, and they find both that they have all this untapped potential intellectual property or actual intellectual property that they could utilize, whether it's just to protect it, whether it's to develop new lines of business, or frankly, to license to third parties. A lot of companies, sort of the classic scenario is, you make a widget, right? But making the widget is not as simple as it sounds like. Oh, it's just a widget. It's a complicated process. And maybe you want to license out the process for making the widget to third parties. And okay, you're licensing your competitors, but guess what? Your competitors are tied to you and are subject to your license on how to make it. Okay, so you also are selling the widget, but you're licensing it out. And so, or maybe you're leaving an industry because for whatever reason, or vertical, for whatever reason, the powers that be within your organization don't like it anymore. Business, financial, political, whatever. You can sell it now to someone else who might want to, or and there's all different creative things you can do. And then, frankly, as an investor or as a company, and I jokingly call them FOCT companies, former operating companies.
Okay.
That I have to amuse. If you can't amuse yourself, who can you amuse? So, but these companies, if they have IP, a lot of them do, and it's a way to recapture the value, because the truth is we're all trying, right? Everyone's trying in the business world, and sometimes we're ahead of our time. And if you're in a technology space and you're ahead of your time and you have patents, sometimes you fail, but you have the patents, and then people catch up to you, and you say, well, wait a second here. I still have these patents, forget the political rightness of it all. You do have this value. And, I have at least 2 or 3 different companies that I'm working with presently that are exactly in that scenario. And they were 10, 15 years ahead of their time. They have these patents, and, now everyone's doing it and making tremendous amounts of money. Why should they be able to free ride on their technology? And so you can create licensing vehicles, or it doesn't have to be as much as suing them. You could theoretically make it friendly, and it depends on where you are in the business, or you could be in bankruptcy, and the bankruptcy estate says, like, look, what can we do with these assets here? And I'll get you money for it. The problem, of course, there is often, not always, companies fail for good reason. And the IP reflects those good reasons for failure. So it may not be successful, but that's not always the case. And sometimes it's just life happens.
Yeah.
So
it definitely is a fascinating world, and it's we're self-sponsored. You're a past client of ours on actually all three of our major services. And so if I may, I just wanted to take a moment of what that is, because before I even do that, you've created quite a bit of content online that is free for the taking. So please do, guys, check out KidonIP.com, which is your website. You're on LinkedIn at David Levy Cohen. Your YouTube channel will have a link below. It's too long to list it out. But you're on Facebook at David L. Cohen PC, and you're on Twitter at David L. Cohen PC. And do look up your YouTube channel, because you've got some great interviews that you've done with, I think, some clients, as well as
some have been even consequential. A couple, I think, made it in as exhibits in trials.
So there you go, folks. So this is not just content for purposes of marketing. This is content for purposes of actually helping people. And I applaud you for doing that. But that's kind of what we do as a company. We're publishers, we're producers, we insert at the level that we found that most of our clients were really struggling with, and that was, how do you create content that actually helps people, that it actually makes a difference, that's not perceived as blatantly self-promotional, that helps to build an audience, that helps to create community, perhaps, and maybe for those of us who are inspiring to be other than just a competent professional or a competent practitioner, that we may also want to actually become an influencer. And in doing so, years ago, almost 15 years ago, we invented the phone blogger process, which is, we called our clients, interviewed them for 5-10 minutes, recorded that information, had a professional editor turn that into an article. Our clients are the authors. We're not ghostwriting. We're basically pulling content from people, because getting that content created is the hard part. Entree Video, several years later, now 4 years in, coming up on 5 years in, we're Video Socials.net was born, and I know you were also a part of that for a while, and that is, who knows how to get on camera? Who knows how to talk to this inanimate object called a camera and have a conversation with an audience, rather than trying to present information and features and benefits and blah 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 blah.
Well, Mark, if I may even add, one of the things
Sure.
that I really enjoyed about the interviews that I was doing with you guys was, we live in a time where there's a lot of toxicity, especially as you get into social media, and when you, even in the context of professional social media, what was really enjoyable about the interviews that I was doing, was that you're talking with people professionally, in a professional manner, at a higher level, not about, at least I structured, so I wasn't talking about, the bric-a-bracs of the day, but sort of bigger picture issues, and why we're doing it, what's going on, fascinating stuff. And it was like professionally therapeutic. A step back, and you're talking about like why am I in this business to begin with? Right. What is interesting to me, and it sort of rekindled a fascination, intellectual fascination about various topics, and it also provided a platform for my interviewees to sell their wares, as it were, but not in a crudely commercial way, but in a way that whatever they got out of it, and I think you covered a lot what they got out of it. I know what I got out of it was that it was sort of like enriching to me to talk to people in a way for an hour and listen to their wisdom and their their experiences, and maybe learn something. And it was sort of energizing in that way.
Yeah, absolutely. And what you're talking about is our VIP service, or videointerviewpodcast.com. which is the next level, as it were, of video socials. So if you're looking to get on video, the best place to start, and there's no cost, there's no obligation. It's just to come in as a guest to videosocials.net. Just click on the guest tab at the top of the screen. We'd love to have you and get you started on what is always a journey, but it basically comes down to having the support, the encouragement of a community, and in that community, learning by doing. Right. So it's not a curriculum per se, but the ancillary benefits are innumerable. So anyway, videosocials.net, videointerviewpodcast.com, and phoneblogger.net. So David, I did want to look at, and I think we've started to touch on this, but there are challenges and opportunities in IP market making. What do you think are the biggest ones? And for those that may not know, what is IP market making?
Right. So IP market making is a term that I may have invented. I'm the one. I use it. I haven't heard anyone else use it. So I'll tell you what it means. So it comes from when I was a chief legal officer for a publicly traded company. A market maker in the security sense, people understand, that's the person who marries the buyer and the seller of securities in a public securities exchange. Mm-hmm. And that's what they do, right? So there's market making. So what I've been doing in IP market making is, if you think about the making of money from IP, there's really three legs. There's the IP rights holder, whether you're the creator or you're the owner or the company, whatever that has the IP rights. There is the entity, people, person, whatever, who will execute on the operations. Mm-hmm. Usually it's lawyers, often it's litigators, sometimes it's licensing executives, sometimes it's engineers, because you need someone to actually build the thing, or you need someone to just sort of advise on the technical aspects of what the lawyers or licensing people are. And then you need the money, because life's not free, and this stuff often costs money, and it's often very risky. So you need a certain kind of money. So the IP market making is sort of marrying these three legs to put together a stool on which the licensing program, the litigation program, the new OEM program, outsourced, whatever. I forgot what it stands for now. I'm sorry, not enough coffee. Or the manufacturing program, or whatever it is, can stand. And so what my job is, I work with. I'm comfortable. Some more comfortable with others, but I'm comfortable working with all three groups. They're all very distinct kinds of personalities. Lawyers, inventors, and capital all have interesting personality quirks. Let's put it that way. And working with those folks, and I sort of marry them up with using my Rolodex and my skills and whatnot, and put them together into some sort of vehicle, whether it's a subsidiary of an existing company, a brand new subsidiary, or within an existing company that will execute. And what I generally do, I prefer to, I'm not here to I'm not doing this for my health, obviously. I could be on the beach or God knows what, but so I prefer to structure it so that once the deal closes, like if you want to pay me for my time to do it, I will take your money. I appreciate it. But generally, I don't get paid until the deal closes. And then I like to run it, because a lot of IP monetization is what I call performative. You can have two great people who are great at their jobs, but one person is better in the situation than the other. And so, I've been there, done that. So I will try to execute, make sure the trains run on time, coordinate, the questions between these three legs of the stool, as it were. And, try to share in some of the upside. It all depends. If you're going to pay me a lot of stipend to do, I'll take less of the less in sort of the upside, however it's structured, because typically, the money in this space is not cheap because they're investing and it's a highly risky endeavor. Of course, if you're just if you're just a straight out manufacturing or building out, then that's a lower level of risk. Sometimes, if you're engaging in a very speculative licensing or litigation campaign, it's much higher risk, and so you have people. You need a certain kind of people, and so your question was the challenges. The challenges, I think, are basically people don't appreciate the situation. So first, inventors, innovators.
Mm-hmm.
I like to joke. I can't tell you how many times I've met the person who invented the next best thing since sliced bread, and they're owed $1 trillion. I'm doing my best. Adjusting expectations there is very challenging because you need to get them on your side, and you're sort of trying to pump them up that you do have innovation worth building on and licensing and whatever. But let's be realistic, and it's very hard for people who've devoted, blood, sweat, and tears to something to be "quote unquote" realistic, because the world doesn't care. That's the problem.
Right.
And then you have operations. Whether they're engineers, licensed, or lawyers, you want people who are willing to offer some skin in the game, but you don't want people who, but you want to have the incentives correct. So it's a general matter. I don't like full contingency law firms because it creates a lot of perverse incentives. I like mixed contingency, but once you start, paying them some money, deferring some of the money you would have paid them otherwise to some sort of contingency arrangement, there's an infinite number of varieties, and you want lawyers, licensing executives who understand the business model of IP market making and IP monetization, who are willing to play, because it's challenging, because the biggest challenge is the money people, and it depends on where the money's coming from, and you need to understand their concerns and their risks. And sometimes it's just a family office that just likes to invest in interesting things, and for them it's about the story, and they love the story, and they don't care about the risk. Other times it's a very, very, very sophisticated operation that has determined the risk levels to the nth degree, and knows if you spend $10 more on this activity within the project as opposed to that, you're going to mess up their whole risk algorithm, and they're going to got you covered. And right, so you need to know how to talk to them. And for all the money, they're providing the money, even though they, the money's always right. Let's just put it that way. Even if they're not. and
the customer's always right? Right.
Well, the customer's always right. And at the end of the day, it's a weird, because you have three customers, because the law firm also is this sort of, I'm sorry, I'm coming too close to the camera. The law firm also, or the licensing folks, are also a partner in this process, because they're sharing in the upside. And so how does that work? And there's a whole bunch of ethical challenges. I mean, not that it's challenging ethically, but there are the rules governing lawyers, which is how I prefer to call it, but they call them the ethics rules. The rules governing lawyers make this sort of challenging, and you need to know how to navigate that. And then, the inventors' expectations and how much they want to be involved, how little they want to be involved. And then, of course, once the program is set up, unless it's just to build something, and then you're just dealing with traditional competitors in the marketplace, it's a rough landscape out there for people who are trying to license IP. For better or worse, there is this culture of what's called efficient infringement. And I think that's across the board, forgetting even IP, it's across the board in business relations. Time was, you did something, you wanted to do something, you sort of asked permission from a business perspective, or you did a clearance thing, and then you did it. Now it's sort of like you do what you want, and if you get caught and are forced to ask for forgiveness and pay compensation, but only if you're caught and forced to. And so, that seems to be across the board, and that sort of makes IP, which is challenging to begin with, even more challenging. And there are, of course, plenty of exceptions. We're not in, we don't live in anarchy, so there are exceptions. And I would say the exceptions are I guess the rule still holds, because then we would be in anarchy, but the exceptions to the rule of this efficient infringement approach are far greater than they were even 20 years ago, even 10 years ago, far greater, and it makes it very challenging. So you need to sort of know how to adjust expectations, when a victory is a victory, when to declare victory and move on. All of those things, you and I both have gray hair, and for better or worse, those are things that it's very hard to learn without the trials and travails that give you the gray hair in the first place.
Exactly, that experience, and I don't want to interrupt your thought process, but we are going to run out of time here in
sorry.
And I wanted to bring in the dirty little secret about the dirty truth about patents. And that, because I know people love to talk about how innovation is so important for the economy, and patents are so crucial to foster that innovation. But really, the challenge is the fact that most people don't want to talk about the dirty truth about it. And that is in order for those patents to have value, they have to at least include some threat of litigation.
100%, because a patent doesn't give you any right other than the right to sue someone. You have a patent on something, it doesn't give you the right to make it, because other people may have subsidiary rights to that thing. So, if you have a right to make a chair, someone may have a right to make a seating implement with 4 legs and can stop you, right? So just because you have a patent doesn't mean you have the right to make it. And someone else can make that chair. The only way you can stop them, all else being equal, right? Assuming that there's no contractual obligations or whatever else, and it's not otherwise regulated, like say in pharmaceuticals, because you can't just make drugs and sell them. Well, in theory, legally anyway, right? The only way you can stop them is to threaten patent litigation. And some companies, as I said before, will more than happily do clearance because they care, or maybe there's antitrust concerns, so they'll do clearance, or licensing discussions. And sometimes they'll drag their feet. Sometimes they'll say that they'll use the fact that they know that you have to sue them to get the maximum amount of money. So they'll try to get you on a bad deal. And more often than not, you have to sue them. I mean, with all due respect to Apple as a company, their CEO, I think Tim Cook, he said something to the effect that taking a license to patents where he doesn't have to would be a violation of his fiduciary duty to his shareholders to maximize shareholder return. So that kind of attitude, because they tend to win in litigation. So from that perspective, sure, and it that makes it hard. And what people don't realize is that from you and I to have an interaction with patents, we don't have to sue each other, right? But someone somewhere has to think that there's an interim value to that patent, that they're for them to be worried about it. Otherwise, yes, I talked about at the top of the call, there are many, many reasons to get patents that don't relate to litigation. It's a proxy for things. It's a box checking exercise that you're serious for startup. But if you're talking about like real value, as opposed to these initial values, now maybe that's real enough for you and for your business and your purposes, great. But there's a lot of patents out there, and the primary purpose of patents are litigation. Sorry to say, and people don't like that. And all the companies, a lot of companies talk about patent litigation as if it's a plague and it's bad. But that's the system. Like, you need to have the patent litigation. Do people abuse the system? Without a doubt, there are many, and we're running out of time. And I'm not going to talk about the troll narrative and how true it is or isn't true, and who are bad players and stuff. But there are a lot of bad players out there on both sides. But definitely, don't get me wrong, there are a lot of bad players on people who are sort of certain ones. But especially in what I do in the IP market making, if you actually go with legitimate funders, because most of them are highly risk averse, they put you through the paces for the diligence. And so if one of those programs gets created, they're not a bad player. They can always play, shenanigans in court, but that patent and that strategy has been highly vetted, because there's a lot of money on the line that they're very concerned about. But that's the truth. So,
well, David, I so appreciate the fact that, because we have IP attorneys as clients. We've had others in the past, and I kind of feel like, for me, this conversation kind of takes a step up or a step back to see it more from the 30,000-foot elevation, more from what, frankly, what's the philosophy behind it? And I think that we've started, you've started to address that, as well as, we could literally go on all day, but we are at a time. I do so appreciate you taking the time today to have this conversation, to share your knowledge and experience, and I wish you nothing but the best moving forward. And folks, please do check out all the links for how to connect with David and how to find his amazing content online. Will be associated with this podcast and whatever platform that you're on. And thank you again, David. You have a great one.
Thank you. My pleasure. Great to see you again, Mark.
Good to see you.
You've been listening to Inspiring Business with your host, Mark Bullock. Your positive comments, likes, and most importantly, your sharing of this show with others is greatly appreciated. Don't forget to subscribe to the Inspiring Business Podcast on whatever platform you prefer. You can catch prior episodes on videosocials.net and on YouTube, LinkedIn, Facebook, and all the major podcast platforms.